Hi, I'm Tristan, and this is Thinking About Politics. So today we continue our fight against the Arizona Fraudit and trying to debunk false claims of election irregularities and fraud in the 2020 presidential election. In our last episode, we started to examine some of the court cases that Sidney Powell, who is the Trump advisor and attorney, brought throughout the country with false allegations of fraud. The first case we're looking at is Bowyers v. Ducey. Last time we gave a quick overview of the case and the complaint and gave a thumbnail sketch of what happened. Today, we're going to dig a little bit deeper and really ask, was there any merit at all to the claims that were brought by Sidney Powell and the Trump supporters in this case? As we'll find out, the answer is no. And we'll have to ask ourselves, so why exactly would attorneys bring lawsuits that were so fatally flawed? But if you're new again here, why don't you take a moment to hit the like and subscribe button. Join us in our fight for facts, decency, and democracy. We sure could use your help. And as always, if you have a friend, family, or other loved one who has been taken in by these lies, please share these videos with them. We don't make this content because we hate Trump supporters. We make this content because we love America. And it makes us sad to see so many of our countrymen lied to by billionaires and be taken in by this effort to overturn American democracy. So when we talked last time, we talked a little bit about Lawsuits 101 and how, the whole lawsuit will kick off with a piece of paper called the complaint, and you throw it at the person you want to sue, and you throw it at the court where you want to sue the person. And if everything goes just right, the other person has to come into that court and answer your complaint. And we talked about how a court, when they get a piece of paper like that, will have to, if it's a real claim, everything can go ahead. Well, if it's not a real claim, well, the court's allowed to just throw it out. And when I say real claim, I mean something like tack in the pie. Opening up a pre-wrapped fruit pie you bought at the local convenience store, biting into it, and getting a mouthful of thumbtacks. That's a real claim. But what's not a real claim? Walking in the elevator and Sally didn't smile at me. Biting into a mouthful of thumbtacks? That hurts. That causes injury. Whoever makes those fruit pies has a duty not to fill them with thumbtacks. Sally not smiling at you? Well, there's really no harm there, even if it hurts your feelings. And she ain't under no duty to smile at you. Sorry. And we talked about how the court in this case said what the plaintiffs filed here, that's the people throwing the piece of paper, what these Republicans filed was a no-smile Sally. This was not a case of tack in the pie. This is a case of Sally not smiling at you. And although this case did not reach the merits of the plaintiff's claims, meaning they didn't actually weigh any evidence, this is no mere technicality, right? Supporters of this fraud cannot hide behind the idea that this was some technicality and the evidence has never been heard. We're going to show you today that if you read this opinion, the opinion was decided the way it was decided because there's no way what was alleged could amount to fraud. So the first thing to know is that this was decided largely on a grounds of standing. So what's standing? Well, in the United States, anybody can sue anybody else. But the court's only going to hear your case if you have standing to sue. One way to think about it is when I bite into that tack in the pie, somebody across the street can't sue the fruit company on my behalf, right? They can't sue the fruit company and say, hey, you filled the fruit pie with thumbtacks. That's true, but you never bit into the thumbtack pie. You never got injured. Or no smile Sally. You can go in and say, hey, judge, Sally didn't smile at me, but there's no injury there. Judge is going to say, yeah, whatever. Sally doesn't smile at anybody. She's just kind of, whatever. Standing is to ensure that courts respect the proper role in a democratic society. So to establish standing, a plaintiff has to do three things. They have to demonstrate that they've suffered an injury in fact. They have to show that the injury is fairly traceable to the challenged conduct of the defendant. It is likely to be redressed by a favorable judicial decision. So a plaintiff has to show that they faced a real injury, something that is concrete and particularized in the court's language. Quote, actual or imminent, not conjectural or hypothetical. And the court continues to belabor this fact. They then go on to describe concrete as meaning real, and not abstract. We said in the last video that the back and forth between the sides are all governed by civil rules of procedure. Rule 12 gives the court a number of reasons to flush a case. In paragraph B, subparagraph 1 is a no-smile Sally. Dismissal of a complaint for lack of subject matter jurisdiction is not something that's done lightly. There's case law that says dismissal of the complaint upon the ground of lack of jurisdiction of the subject matter would therefore be justified only if the claim were so attenuated and unsubstantial as to be absolutely devoid of merit or frivolous. That the claim is unsubstantial must be very plain. Attenuated, unsubstantial, devoid of merit, frivolous. These are the words that describe cases that are thrown out for want of subject matter jurisdiction, such as the one filed by Donald Trump's attorney, Sidney Powell. Frivolous. These cases were so frivolous in other jurisdictions. Sidney Powell, Ellen Wood, and others who manufactured these things might actually face disciplinary action for lying. The court consolidates this complaint into 3 main counts. In count 1, the plaintiffs allege violations of the Constitution, specifically the elections and the electors clauses. See, the electors clause just says the state has the power to appoint electors, and the elections clause says the state can choose the time, place, and manner of elections. So right or wrong, one of the things that's fairly established in law is that citizens don't have standing to sue for general grievances of government. Your solution for your political problems are going to be found in the political arena. Running for office, supporting candidates, that sort of thing. In order to bring a suit, you need to have a real particularized grievance, something that's unique to you. So the court here is saying, Joe Schmo can't bring suit and say, hey, the state violated the elections clause or the electors clause, because really that just says the state has the power to do things. If your gripe is you think the state decided wrong, well, they have the power to decide. You need some sort of particularized injury that you've suffered. And you know who would have suffered a particularized injury? President Trump. If President Trump thought there was fraud here, I wonder why he didn't file suit. Because if his name was on this, he would have cleared the standing problem just fine. The court even says that a presidential candidate running for office would have unquestionably suffered discrete injury required for standing. Notably, the Republican candidate whose name was on the ballot is not a plaintiff in this case. The second count the court tangles with is the count of vote delusion. The plaintiffs allege that the equal protection violations based on the defendant's failure to comply with Arizona law by permitting illegal votes, allowing voting fraud and manipulation in the preventing of actual observation and access of the electoral process, which allegedly resulted in the dilution of lawful votes and the counting of unlawful votes. And the court notes that absent from the complaint is an allegation from the plaintiffs, or any registered Arizona voter for that matter, were deprived of their right to vote. Instead, they bring baseless claims of disparate treatment of voters in subjecting one class of voters to greater burdens or scrutiny than another. They do not allege what class of voters were treated disparately. With vote delusion, it's a very specific claim, and it involves different votes being weighed differently. And the court notes, and I'm sure this is going to have some controversy, that a violation of state election laws by state officials or other unidentified third parties is not always amenable to a federal constitutional claim. So although the plaintiff has a number of individual acts it takes issue with, the court's not even looking at them. It's just saying, look, even if these were individual wrongful acts, violations of state law, that doesn't necessarily make them a federal constitutional claim. Your claim's probably under the state government someplace. And the court goes on to state that even if they could somehow establish that their vote delusion claim was more than a general grievance, more than just kind of a generalized complaint, they failed to show that the court can actually redress their grievance in any way. So the court doesn't think that they've been harmed, and even if they've been harmed, they don't think that the solution to the problem they're asking for is really going to do them any good. It's not narrowly tailored to the thing that's been alleged. I'm going to skip the parts that go through the grounds of abstention, which essentially say sometimes the court can abstain from jumping in the middle of something, especially where, like this case, there was a companion case that was already decided in state court. The federal court says, yeah, why would the federal court try to decide something that the state court is already looking into? we'd probably reach the same conclusion, but what if we did it by different reasoning? That wouldn't look good. And then it goes through the 11th Amendment claims as well. I won't bore you by talking about sovereign immunity. And it also talks about latches. Again, I'm not going to bore you with that, but it's essentially when you wait too long to file a claim. But here's really what I want to highlight at the end. Remember last time when we talked about Rule 9b? It says that when you're alleging fraud, you need to plead with particularity. The circumstances giving rise to that fraud. Well, the court explains that this means giving us at least the who, what, where, when, and how. And it's not enough just to plead something that's like conceivable within the universe of stuff you can imagine. I can imagine Russian space lasers coming down and changing all the votes. I can imagine angry leprechauns materializing out of nothing and running around the polling place and knocking everything over. I can imagine a lot. Doesn't make it plausible. So just because you allege something doesn't mean it's plausible. Although a plaintiff's specific allegations may be consistent with a plaintiff's claim, a district court must assess whether there are more likely explanations for the defendant's conduct, such that a plaintiff's claim cannot cross the line from conceivable to plausible. And don't you see that's what happened here? I'm just going to read from the court case here. The plaintiffs allege that the Arizona Secretary of State and the governor conspired with various domestic and international actors to manipulate Arizona's 2020 general election results, allowing Joseph Biden to defeat Donald Trump in the presidential race. The allegations they put forth to support their claims of fraud fail in their particularity and their plausibility. Plaintiffs append over 300 pages of attachments, which are only impressive for their volume. Court is not impressed. The various affidavits and expert reports are largely based on anonymous witnesses, hearsay, and irrelevant analysis of unrelated elections. The plaintiffs first describe violations of Arizona law to support their fraud claims. They attach declarations from poll watchers that observed officials during the November general election. As one of the defendants points out, these are the only declarants offered by the plaintiff with first-hand observations of election administration. So they're basing their entire fraud argument on the eyewitness testimony of 4 people. 4 people observed something. But these 4 declarants do not allege fraud at all. Instead, they raise objections to the manner and process by which Arizona elections officials match signatures on absentee ballots, to the process and the role assigned to poll referees in settling unresolved disputes between adjudicators, to irregularities with voting machines on Election Day and before, and to the certification of the Dominion voting systems on November 18, 2020. These objections to the manner in which Arizona officials administered the election cannot serve to overturn the results of the 2020 presidential election in Arizona because they fail to present evidence that supports the underlying fraud claim. At most, these are the type of garden variety election irregularities federal courts are not equipped nor empowered to supervise. I just want to make this clear. This judge is slicing through all this evidence, saying this does not matter. You have not alleged fraud. None of this means fraud. None of it. The complaint is equally void of plausible allegations that Dominion voting machines were actually hacked or compromised in Arizona during the 2020 general election. Plaintiffs are clearly concerned about the vulnerabilities of voting machines used in some counties across Arizona and in some other states. They cite sources that attest to knowledge of, quote, well-known vulnerabilities that have included letters from concerned citizens, Arizona elected officials, and U.S. senators. Plaintiffs even attach an affidavit of an anonymous witness with connections to the late Venezuelan dictator Hugo Chavez, claiming to be privy as to how officials in Venezuela rigged their elections with the help of a voting systems company whose software DNA is now somehow in the voting machines in the United States. These concerns and stated vulnerabilities, however, do not sufficiently allege that any voting machines used in Arizona was in fact hacked or compromised in the 2020 general election. Rather, what is present is a lengthy collection of phrases beginning with the words could have, possibly, might, and may have. Plaintiffs have not moved the needle on their fraud theory from conceivable to plausible. Court is telling them to go take a hike. So the judge is telling us that this is so ludicrous. This is so fallacious. There's absolutely no reasonable way anybody would look at any of this and come away with anything but, what we and the judge have concluded here. For the fraud claims themselves are a fraud. So why are they filing these suits? Well, you file this because there's enough of the population out there that is so hoodwinked, that has drank the Kool-Aid so deeply, they're not going to get confronted by facts. I've said before, what is motivating these Arizona fraud claims and other election fraud claims are two things. One, more likely than not, for the majority of folks who know better and know that this is a lie but repeat it anyway, they see political benefit in it. But there are people who are using these claims because they want to incite violence, because it's in greater political violence that they see their greatest opportunity to make the changes that they want in this world. And this movement has already proven itself violent. They've already drawn blood. And I'm really afraid it's only a matter of time before they do it again. So that's not happy. But we'll come back later in the week. We're going to change the topic just for an episode. But until next time,
I ain't got
keep
time to
thinking.
kiss you now. I'm busy with this music.